Mr. Falcone, can you unmute yourself and please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give here in this case shall be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
Yes.
Thank you.
Honorable Kathleen Sigurdson, presiding.
Good morning. Please be seated. Higginbotham, when you're ready, could you call our case?
Yes, Your Honor. Robert A. Conrad versus Washoe County in case number CB 24-00231. Matter set for a hearing on petition. Counsel, please state your name for the record.
Good morning, Your Honor. Luke Busby, appearing for petitioner Robert Conrad, who's with me as well. And Mr. Falcone is on video and also here on behalf of our Nevada judges.
Excellent. Thank you very much, Mr. Busby.
Thank you.
I'm Lindsay Liddel, Deputy District Attorney on behalf of Washoe County.
Good morning, ma'am.
Thank you.
All right, we did receive an order from our Supreme Court that was dated August 21st, 2024. In that, it granted the writ and basically gave instructions to the court. Further findings of fact were needed if I was to continue to deny coverage. With that, I would like to hear, let me back up. There have been some motions that have been filed and some oppositions there too, but they are not ripe for argument today because we have more motion practice to be had. So, with that thought, Mr. Busby, how would you like us to proceed?
Thank you, Judge. If I may, I'd like to ask Mr. Falcone to testify before the court, describe our Nevada judges, their processes, the procedures, the kinds of cases they cover, and to go through the SCR 230 factors with the witness.
Okay, I was not planning on having any evidence presented today, including testimony. More to discuss the Supreme Court decision and how we proceed therein based on their decision. If we want to have an evidentiary hearing, I will certainly set this on the calendar to do so. But today I only have a allotted amount of time to go over the decision and decide how we're going to proceed.
Understood, Your Honor, and not that I'm glad to provide arguments under the SCR 230 factors, but we would object on the basis that we think some facts laid out about what our Nevada judges does, how this occurs, what kinds of cases he's provided coverage in, would help inform the court as to the appropriate weighing of the facts under the SCR 230 factors.
Okay, I will allow this testimony, but I would advise you, like I said, we have limited time this morning, so with that in mind.
Thank you, Judge. If I may, urgently.
Yes,
And I'll do my best to make this as quick as possible.
understood. Thank you very much, Mr. Busby.
Your Honor, could I ask the witness to be sworn?
Yes.
Mr. Falcone, can you unmute yourself and please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give here in this case shall be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
Yes.
Thank you.
All right, Mr. Falcone, good morning. You heard the judge. We're going to do this as quickly as we can. Can you describe very briefly what our Nevada Judges is?
Our Nevada Judges is a nonprofit corporation that attempts to bridge the gap between the public and the judiciary by statistical analysis of appellate dispositions and by providing electronic coverage of court proceedings.
Thank you, Mr. Falcone. Can you give the court an idea of the type of proceedings that you cover?
All of them. I mean, one of the reasons why we litigated access to family court is because we wanted to give the public a presentation of all of the types of cases in Nevada, not just certain cases.
Okay. So you mentioned that you do cover family court proceedings?
Yes, we do.
And are there any limitations that are placed on coverage in family court proceedings?
We place our own limitations on the parents and children, and then some of the family court judges place the same limitations through a court order and occasionally more restrictive requirements.
Okay. And if a judge orders you to, say, not disclose the identity of a particular witness in a case, how do you go about doing that technically?
We provide visual redactions and we provide audio redactions.
All right, and when you cover family law proceedings, you're essentially videotaping what people's personal lives, very personal issues. Is that right?
Right.
Okay. Have you ever covered criminal matters that are similar, such as guardianships, things like that?
Things like that.
Yes, we have actually. The
Okay, can you-
criminal proceedings that involve child abuse and neglect, we have covered them before, and some of them have sexual abuse situations and such, and we provide the same protections for the victims.
Okay. All right, so you're familiar with the SCR 230 factors, Mr. Falcone?
I'm familiar with them, yes.
All right. How does our Nevada judges address the impact of coverage upon the right of any party to a fair trial when that's an issue?
I've stated before in front of District Court Judge Breslow that under no circumstances would I allow that to occur.
And as a practical matter, how would you ensure that?
It depends. In the past, we've had a litigant, a defendant, face the camera and tear a piece of paper of a legal court order to the audience, and we edit that out.
Okay. So you're basically saying that you take measures such that if someone abuses the presence of the camera in the courtroom in order to influence the public's perception of what's happening, you don't allow that, essentially.
My major concern is that I don't want the litigants to take their attention off of the process, and if they do that, I do not encourage it by removing it from the footage. Otherwise, they would be encouraged to do that even more, which is not appropriate.
Understood. Moving to the next factor, the impact of coverage upon the right of privacy of any party or witness. How does our Nevada judges accommodate this factor when it's necessary?
Well, the purpose of the videos is to educate and inform the public. And in family court cases, the public is learning the process. The names of the parents and the children and their video footage of their faces and such is not necessary to accomplish that objective. And in fact, causes us as much frustration from our viewers as it most likely causes the government. We have a very similar objective, which is to serve the public, and we don't need court orders to do that because our own viewers will confront us. We have our own incentive to protect parents and kids.
Okay. And how about the impact of coverage, the next factor, the impact of coverage on the safety and well-being of any party, witness, or juror? How does our Nevada judges address that factor?
One of the obvious examples was a request by one of the prosecutors in this county, 2nd Judicial District Court, that he felt he was in danger, and so we removed his images from the videos.
Moving to the next factor, the likelihood that coverage would distract participants or would detract from the dignity of the proceedings. I think we kind of covered that under factor A, but do you have anything in addition to add to how our Nevada judges addresses this factor?
It is simply important that we do not exacerbate that problem by encouraging it. So if we see that occur, we remove it from the footage to discourage that in the future.
And how about the adequacy of the physical facilities? Have you ever had any issues in terms of that factor in providing coverage of court proceedings in Nevada?
No, some of the courtrooms in the rural judicial districts are quite small, and my perception is that those justices of the peace bend over backwards to allow electronic coverage.
Okay. Thank you, Mr. Falcone. And I guess the last factor, any other factor affecting the fair administration of justice, if there's anything you'd like to tell the court about how Nevada judges operates and what it does, this is your opportunity.
If the district court judge has additional questions, I'd be happy to answer them.
Right. Thank you, Judge.
Thank you, Mr. Busby. Thank you, Mr. Falcone. Mr. Falcone, I just want to make sure you understand this is a district court that we're currently in, not a family law courtroom. So this is a civil matter that this all stems from. Do you understand that, sir?
I understand that.
And I know a lot of the questions were geared towards family, and I understand the family court deals with very sensitive issues, and I imagine that's why Mr. Busby chose to ask you about those. But this particular case that we are talking about is a civil matter with regards to two adult people. You understand that and that?
I understand that. We cover those cases routinely.
Thank you very much, sir. Any questions?
Yes, Your Honor. Mr. Falcone, good morning.
Good morning.
Isn't it true that our Nevada judges, when they record proceedings, you generally post an edited video on your YouTube channel? Is that correct?
The YouTube channel, and the Facebook channel, and also Twitter.
Thank you. And are all of those posts public?
Yes.
And generally, you talked about witness redaction. When the witness is an adult, do you generally blur their faces?
In a domestic relations matter, yes. Otherwise, they have to request it, and we weigh the public's perception of it. We try to do what we think the public would expect. So with victims would be more likely. Certain witnesses are reluctant to participate, for example, a teacher. We are resistant maybe towards expert witnesses who are being paid thousands of dollars. We're resistant towards like a police officer, other government officials. But despite the fact that we are resistant to do this, if the district court judge orders it, we will comply with the order.
And would you say that any redactions that our Nevada judges does is subject to human error?
Yes, luckily YouTube allows something called a post-edit. So when that occurs, we edit it post-production.
Thank you. I have no further questions.
Thank you. Any redirect, Mr. Busby?
Nothing, Your Honor, thank you.
Thank you, Mr. Falcone. You are excused. You're welcome to watch if you'd like to, sir.
Thank you.
Mr. Busby, anything further?
Thank you, Judge. I'd just like to make a brief argument.
Absolutely.
Approach.
Yes.
Thank you, Judge.
Just for clarification, you are not arguing with regards to the motion practice that is in play.
Just the media request, Your Honor.
All right,
Okay,
thank you, sir.
I'll make it as speedy as I can.
That's fine.
In the recent Falcone decision that was issued by the Supreme Court, the Nevada Supreme Court made it crystal clear that in all civil proceedings, the media, under the First Amendment, has the right to access the court. And that decision is also embodied in the Supreme Court's rules when it comes to electronic coverage of court proceedings in the state of Nevada. And the court has been quite clear that there's a presumption that all courtroom proceedings are open to the public and they're subject to electronic coverage. And when a media request is made, particularized findings on the record are required to show whether it should be admitted or denied or curtailed in terms of blurring witness faces, things like that. So exclusion from the courtroom in whole requires strict scrutiny analysis, meaning a compelling government interest, and any closure has to be narrowly tailored to serve that interest. The court in Falcone was quite clear that it's not appropriate to just completely close Nevada courts to the press. In terms of the SCR 230 factors, the coverage won't have any impact on the parties' right to fair trial. The parties here are Washoe County and Dr. Conrad. They're not other witnesses. The impact of coverage on the right of privacy of any party or witness. Well, we're looking for public records, things that the police produce. There's no privacy interest in police reports once they produce them if they're not otherwise covered by some statute or regulation, or the court determines ultimately that the record shouldn't be disclosed under the CCSD test. But preventing testimony or electronic access or coverage to a court proceeding on that basis before the court makes that determination, we don't think that factor weighs at all in favor of denying or curtailing coverage. The safety or well-being of any party, witness, or juror, the witnesses in this case thus far are Dr. Conrad and whoever Washoe County chooses to call, and our witness who, Mr. Turner, who made a similar public records request that was responded to in full without the kind of redactions that we saw in this case. We don't think there's any, there hasn't been any argument that there's a safety or the well-being of any party, witness, or juror would be affected by electronic coverage in particular. We don't think that coverage would distract participants or detract from the dignity of the proceedings either. As Mr. Falcone explains, he's recorded hundreds and hundreds of proceedings in the state of Nevada involving what could be traditionally called sensitive issues. But that doesn't detract from the dignity of the proceedings. The camera, as you can see there in the background, doesn't obscure anybody's view. It doesn't change the course of proceedings at all. There's no question about facilities. We don't think there's any factor affecting the fair administration of justice in this case. This is ultimately a case about the appropriateness of withholding records police have from a journalist. And that's a case in which the public has a significant interest. So any, if the court were to impose any limitations at all, they should be strictly limited to something that would further the factors that the court, in our view, shouldn't deny coverage in whole. It should permit it. And with that, I'd be glad to answer any questions you have, Judge.
I have none at this time. Thank you, Mr. Busby.
Thank you, Your Honor. I just wanted to clarify that this case involves records of a domestic disturbance call. It involves body cam of private individuals in their home in very vulnerable states discussing a marital dispute, which changes things. However, I wanted to clarify the nature and scope of Washoe County's objection to any media coverage. At issue, we have the Cameron-Macy test, which is whether we have a non-trivial privacy interest, and then whether the public interest outweighs that non-trivial privacy interest. One of the individuals involved in the records was at the time a government employee. One of the things that Conrad and Mr. Busby has argued is that employment diminishes or destroys an ability to assert a privacy interest. And I think that's a question of law, and I don't think that there's a privacy interest or a reason to preclude our Nevada judges from filming any argument on that question of law. The other question of law that I see is the nature of that public interest test. Mr. Busby has argued that it equates to newsworthiness or whether it's interesting and whether it would be consumed by the public. Washoe County, on the other hand, has provided briefing that it is actually an interest in whether the records show how the government functions. And I think any argument on that could be filmed. I think that's fine. But to the extent that we are bringing these private individuals in on witness stand or discussing the actual nature of the records, the privacy interests, the potential chilling effect for victims of domestic violence that this case presents, I would object to publishing any information on that. Thank you, Your Honor.
Thank you very much. Appreciate your presentation. Mr. Busby.
Just very briefly, Your Honor, I think those issues that my friend on the other side presented relate to whether the records themselves should be disclosed or not really the SCR 230 factors, which is what I think we're here to discuss today. We really don't know what this case is about because what we received from the government was little to nothing, a completely blacked out police report, no body cam footage, nothing. So we don't even really know what this case involves. And so under SCR 230, we don't think they've made an adequate showing there should be any particular limitations on electronic coverage under the court. Thank you, Judge.
Thank you, Mr. Busby. At this juncture, what I would like to do is set this for an evidentiary hearing. At that time, I would hope and expect that all motion practice with regards to the decision on the petition to be decided on the papers as filed by the county. And Mr. Busby has already opposed that, so I just need to reply in a submission if that's the course that the county wants to maintain. Nonetheless, Mr. Busby, your presentation with witnesses, how long do you think we need to set it for?
Your Honor, I think that it will essentially be, and this, I'm sorry, Your Honor, this is just the SCR 230 request as well as Washoe County's motion to hear the case on the papers. Is that
Correct,
right?
that's correct.
Oh, I can't imagine it taking more than an hour and a half.
Hour and a half? Ms. Liddel for the county?
Can I clarify, it sounds like a evidentiary hearing would not be on the petition itself, or is that what the court would like to say?
Actually, Mr. Busby, I take that back. I think I do want it on the entire petition. If we're going to have another hearing, we'll take everything under consideration.
In that case, Your Honor, we have about 13 exhibits we'd like to submit to the court and 2 witnesses to testify, Dr. Conrad and Mr. Turner. That, again, I think would be about 2 hours. I'm not sure, just for clarification, are we going to get a ruling on the RSC or 230 request before that hearing? Or?
Yes, we will.
Oh, okay. All right, thank you, Judge. In that case, I think 2 hours to put on our case in chief. I don't think it'll take all that long, but we will seek to cross-examine any witnesses that are presented by Washoe County. I'm sure you haven't had a chance to look over our opposition.
No, it was just filed yesterday, so you're absolutely right, yeah.
The argument we essentially make in there is, hey, we've got a lot of examined unquestioned statements here, and we want to cross-examine those witnesses on all of that stuff in front of the court admitted to the hearing, so that can take some time.
Okay.
Sorry to.
So, but if I understand, all of that is 2 hours? Is it? No.
2 hours for our case in chief.
Okay.
I want to just kind of insert in there that I'll have extensive cross-examination of the affiants who presented, that were presented in Washoe County's brief, insofar as they're called to testify by Washoe County.
Okay.
If they're not, we're going to object to the court considering those affidavits as on cross-examination.
Okay.
And just a few things that I'd be willing to stipulate to the exhibits that Mr. Busby filed in the other day. I've no issue with those. And I'd have to examine the case and talk to witnesses about availability and things like that as far as which witnesses I would bring up. I likely would not subject the private individuals who were in the records to cross-examination and to any examination. And I'll be submitting further briefing that the nature of the declarations are more like a summary judgment motion and things like that. So there's no right to cross-examination in that. But to the extent that the court wants to have an evidentiary hearing on the petition, I might have a couple of witnesses that will take maybe 2 hours.
Okay, so we're looking at half a day at least, is what I'm hearing.
I think that would be
Sounds
appropriate.
right to me, Judge.
Okay. Mr. Higginbotham, I don't know, can you find a day for us to do this? I do want a full day just in case it, with the cross-examination, all might take a little longer.
In your honor, how far out would you want to go for the responses?
How long do we need to get to notice and subpoena witnesses to get them in here?
Judge, we're not going to need subpoenas for our witnesses. They'll
Okay.
voluntarily show up.
Okay? Any,
And I don't know, I haven't talked to the domestic violence experts in several months, so I don't know their availability and things like that.
okay, so what I would like to do then, since I can't do it right now, I do want it done. Today is Friday of this week. By next Wednesday, please contact Mr. Higginbotham with your available dates, with your witnesses available, so that we can set this. So give him at least 3 from each of you, and we will try to narrow it down. And I will just advise you, my court calendar is very, very full with the criminal docket, as I know you all know. So just bear that in mind, and your patience is greatly appreciated. We will get through this.
Judge.
All right, with that, we are adjourned. Thank you all very much.
All rise.